frequently asked questions about the role the legislature can play in the California rulemaking process. So first, how many rulemaking bodies roughly are there in California state government? Well, we have well over 200 agencies, departments, board, bureaus, and commissions that can make public policy via their quasi-legislative authority to adopt regulations, often referred to as their rulemaking authority. Can the California legislature impact the rulemaking process? Yes, there are several ways in which the legislature can influence the rulemaking activities of state executive branch agencies, primarily through the lawmaking and budgetary processes. So, what can the legislature do through the legislative process? Well, for example, the legislature can adopt statutory changes to expand or limit a specific state agency or department's authority to adopt either specific or general regulations. What can the legislature do through the budget process? Well, for example, the legislature can utilize the power of the purse strings, as the saying goes, utilizing the budget process to perhaps persuade a state agency or department in their rulemaking actions. Can the legislature actually review a regulation? Yes, under the joint rules of the California legislature, the Joint Committee on Rules, as well as the respective Assembly Rules Committee and Senate Rules Committee, may approve any request for a so-called priority review of a regulation. And this is set forth in the California Government Code section 11349.7. Next, what happens if the legislature approves a request for a priority review of a regulation? Well, if such a request is approved, the Joint Rules Committee must submit any approved request to the Office of Administrative Law, OAL. Can individual legislators actually request regulations be reviewed? Yes, under the joint rules, any member of the Senate may request the Senate Committee on Rules, and any member of the Assembly may request the Speaker of the Assembly to direct a standing committee of their respective House or the Senate or Assembly offices of research to study any proposed or existing regulations or even a group of related regulations. Now, what happens with an individual legislator's request for regulatory review? Essentially, upon receipt of that study request, then the Senate Committee on Rules or the Speaker of the Assembly determines whether a bill will be made or will a study will be made of the regulation or regulations. Are there standards that are used in reviewing these individual legislative requests? Yes, under the joint rules, in reviewing the request, the Senate Committee on Rules or the Speaker of the Assembly is required to determine the cost of making the study, the potential public benefit to be derived from that study, and the scope of the actual study. What is reviewed under a study of a regulation? Well, under those joint rules, the study may consider, among other relevant issues, whether either the proposed regulation or the existing regulation, one, exceeds that agency's statutory authority, two, fails to conform to the legislative intent of the enabling statute, three, contradicts or duplicates other regulations adopted by federal, state, or local agencies, involves an excessive delegation of regulatory authority to a particular state agency, five, unfairly burdens particular elements of the public, six, imposes social or economic costs that outweigh its intended benefits to the public, or seven, imposes unreasonable penalties for a violation of the regulation. So finally, what happens if the state agency chooses to basically continue with its rulemaking despite that determination? Well, in the event that a state agency takes a regulatory action that the reviewing entity finds to be unacceptable, then that entity must file a report for publication in the Senate or Assembly Daily Journal, in other words, of the respective House, indicating the specific reasons why the regulatory action should not have been taken. And the report may include a recommendation that the legislature adopt a concurrent resolution that's adopted by both houses that requests the state agency to reconsider its actions, or that the legislature enact a statute to restrict the regulatory powers of the state agency that has so taken that action.